Hey guys, welcome to HipHughes History. ObamaCare is back in the news. Today in the Supreme Court, King versus Burwell was heard, oral arguments, and this is not a constitutional challenge to Obamacare, but rather a interpretation of the law challenge. That's basically a lawsuit which could shake the world of insurance to the ground if it's decided against Obamacare. But we're going to explain both sides like we always do and walk the line, and then let you decide, and then the Supreme Court will decide in June. So giddy up for it. All right, so let's try and break it down for you. Basically, the way that Obamacare works is there are federal exchanges where people can basically kind of shop for insurance. And if they can't afford it, then the federal government basically subsidizes, gives them money in order for them to afford it. And if the total package is less than 8% of your income, then there is this individual mandate, meaning that you have to buy it or you're going to face tax penalties. But if you don't have that subsidy, if the federal government doesn't give you that money, and then you have over 8% of your income being what insurance would cost you, then the individual mandate doesn't apply. So basically, there's only 16 states that created their own state exchanges. And these state exchanges is in the language of the law. The actual law which describes who is going to be covered by these subsidies says there will be enrolled through an exchange established by the state. An exchange established by the state. That's the language that's the heart of this lawsuit. Because if you're not in one of those 16 states that have state exchanges, you're part of the federal exchange, which was created by Obamacare. So in lieu of your state not having an exchange, the IRS interpreted that statute to basically say whether it's a state exchange or a federal exchange, you're going to get those subsidies. And remember, those subsidies are what allow for that individual mandate to kick in. So if you don't have the subsidy, then you don't have the individual mandate, and then the whole kind of, house of cards falls down. So there's 4 individuals, it's kind of a package lawsuit deal, that claim they have standing. There's 2 Vietnam vets, I believe, that are part of it that actually get free health care. And they're basically saying, we don't want that money, because we don't want health care insurance. It's our choice not to have that. So they have standing going to the court and filing a lawsuit against the HHS, and that's led by Sylvia Matthews Burwell. That's why it's King versus Burwell. But at the end of the day, we're talking about the interpretation of that language. So let's take a look at what the court's going to look at as they look at that language enrolled through an exchange established by the state. So what the Supreme Court does when they look at these types of questions is they normally look back to say, hey, if we decided this thing before, is there some kind of test we have created? And they have created a test in Chevron USA versus Natural Resources Defense Council, which is called the Chevron Test. They came up with basically, how to solve this problem. And number one, they said, if Congress's intention was clear, if they've already stated what their intention was, then you go with Congress's intention. But if it's ambiguous, then basically, if it's a reasonable interpretation, Congress has kind of delegated that regulation of the language of the law to an agency, the agency in this case being the IRS. And the Fourth Court Circuit, who heard this case before it got to the Supreme Court, ruled unanimously that it passed the Chevron test, that it was a reasonable interpretation. And they, kind of had a side note by saying, but, if you're a literalist, if you're not going by intention, if you're going by the language of the law itself, then it does say through states. But in a sense, they're applying, the availability of common sense being afforded to the IRS, because federal exchanges, why do they exist if they're not going to, be subsidized? So they're basically kind of tipping their hat to Congress and to the IRS saying, what you have done is reasonable. But on the other side, the plaintiff is sticking to 2 big points. Number one, they're saying if you look at the actual language, if you're a strict interpretationalist as we are, the purpose is to induce states to join this exchange program. Because the idea is if you don't join it, then your citizens aren't going to get covered. And Jonathan Gruber, who's an MIT economist who was a consultant writing the law, stated in 2012, and maybe it was a threat to try to get more state exchanges, but he said the same type of thing. He basically said, look, our intention is if you don't create a state exchange, then you're going to have millions of people that are going to be uninsured, and that's going to be on your shoulders. So we want you to create a state exchange. And then he's later kind of reinterpreted that by saying, it wasn't really clear what the federal exchanges were going to do. The people that are supporting the law are basically saying that Congress's intention was clear, that this is just common sense, that we wouldn't have federal exchanges without subsidies because that wouldn't solve the problem. So it's kind of inherently understood that's what we were trying to do. And the other argument they kind of have is that the process by which this legislation was passed was a process called reconciliation, where basically there isn't that last chance to edit the bill, that it's in a sense a draft bill that goes to the final cutting room. So they didn't have a chance to sparse every word in there and fix every mistake. But our intention was clear, they state, and of course the other side says, liars, liars, pants on fire. But either way, that's what the Supreme Court is racking with right now. Most political analysis, Supreme Court people who watch this kind of thing, say that right now it's Anthony Kennedy. He's the Supreme Court justice in the middle. It's really probably Kennedy that's going to be the swing vote if this is a 5-4 decision. So let's look at what happens if the plaintiffs in this case win and they don't have to receive money from the federal government in order to induce an individual mandate so they don't have to, want to buy health insurance. So the Rand Corporation, who kind of studies urban affairs and kind of looks at these types of things, basically said the number one group that's going to be affected would be poor working white Southerners. That's the largest percentage of people that are getting subsidies from this federal exchange, and they estimated that it would immediately be about 5 or 6 million people that would lose health insurance because they couldn't afford it, but it could be upwards in the ripple effect to 10 million people losing their health insurance. And they would go on to further explain that this would be catastrophic for the insurance companies because the insurance companies are being made to take on sick people. Part of that law says that if you have a pre-existing condition or we can't drop you, we have to keep you on, and you're dead weight, baby. You cost a lot of money. It's all those healthy people that are keeping us in this game. So if you take all the healthy people out of the equation, then most people are saying that premiums are going to skyrocket, that the whole system could kind of fall down. Republicans and people on the right have said, well, we can mitigate these factors. States can then create their own exchanges like the purpose of the law, and that would take care of the problem. Or we can go into Congress and we can hammer this out and create maybe some type of bipartisan solution so that this wouldn't happen. People on the other say that's poppycock. That's not going to happen. Nothing's going to happen. We're just going to talk this to death that you guys don't have a plan on your side. And we're really talking about 10 million people losing their health insurance and destroying the system from the inside out. So now we're going to think about what you think about that. So I laid out the two sides. There really is, I think, good arguments on both sides. Why don't you guys leave it down in the comments below? And certainly when this decision comes out in June, we're going to even see more comments. But, what would you rule? You decide. And thanks for watching. We hope that you learned a little bit. We always try to do a little bit of learning on the YouTubes when you're watching HipHughes History. If you haven't subscribed, you can hit that big red button which will magically zip you through the internet where you can subscribe for free. For fun, focused, and free lectures. Yeah, we have like 200 or 300 videos, but I'm going to stop talking, guys, and I'm going to always remind you what I tell you at the end of every lecture, which is where attention goes, energy flows. We'll see you guys next time that you press my buttons.